Okie dokie, everybody. You're probably thinking to yourself that your bank account information, let's say US Bank, Wells Fargo, whatever the case may be, is private. I'm going to explain to you why this information is not in fact private, and the officer can use this information against you in the court of law. In a case called Miller, ATF agents got Miller's information from his bank account and used it against him in the court of law. Miller tried to fight the case. Miller said, "What the heck, dude? What the heck, court? You can't use this information against me. This is my private info." But the court said that the third-party doctrine under the Fourth Amendment is exactly what allowed the officers to use this information against him, because he communicated this information voluntarily. He consented to give this information to a third party, the bank. Because he did that, it was no longer a reasonable expectation of privacy, and the cops could get this information and use it against him in the court of law. And he went to jail. Let's go through a quick fact pattern here. I'm going to talk about exactly how an officer can lawfully search your car, okay? So let's say you get pulled to the side of the road for speeding, okay? An officer pulls you over because he or she has reasonable suspicion that you're committing a crime because you just violated a traffic statute, okay? So the stop is lawful. The officer goes up to your car and says, "License, registration, please." And for whatever reason, you look high. Let's say you just got done smoking weed, or you drink a lot of liquor with your friends and you just look drunk. That will give the officer probable cause. And probable cause is the standard we're looking for, because the officer needs probable cause in order to lawfully search your car. Okay, probable cause is when the officer has specific articulable facts that will give the officer a reasonable inference you are committing a crime, okay? Even if the officer sees an open container, okay? As you can see in my car. See the water bottle down there? Let's say that's an open container of liquor. Even if an officer sees that, that could be enough to say, "Get out of the car, I'm going to search your car," and if they find evidence in the car, you can get arrested. Stop and frisk. I'm going to explain to you how an officer can lawfully stop you when you're walking on the street or at the mall or whatever, and how an officer can frisk you, basically patting down your body in order to look for evidence used against you in the court of law, okay? So an officer can actually stop you when he or she has reasonable suspicion. Basically, the officer has a specific fact about why he or she thinks you're committing a crime, and the officer must tell you that reason, okay? The officer can't just stop you just because he or she feels like it, okay? So an officer can take it a step further by frisking your body when he or she thinks that you are armed and dangerous, okay? So let's say that you are walking back and forth in a public street and you're kind of peering into a store, right? That will give an officer reasonable suspicion you're trying to commit a crime within the store, because you're trying to see who's in the store and who can and cannot be a threat if you try to rob it, okay? The officer might think, maybe this person's trying to rob the store, okay? And he'll pat you down because he or she might think you have a gun, okay? Third-party consent. I'm going to explain to you how that exception under the Fourth Amendment can allow an officer to come into your home without a warrant from a judge and look for evidence and possibly put you in jail. Okay, so let's walk through it very briefly. So let's say you have a roommate. You and that person are paying rent, therefore you both have equal authority. Okay, check one, thumbs up. The second thing to think about is that you have to be physically present in order to object to the officer being there. Okay, let's say you're out grocery shopping one day. Okay, your friend's at home, and your friend voluntarily lets an officer into the home because the officer wants to come in and look for evidence, okay? The officer can technically look for evidence in the home even though you don't want him to be there, because your friend with equal authority allowed the officer to get into the home. You have to be physically present in the home in order to stop the officer at the front door to say, "No, you can't come in," okay? So again, if you're physically there, you can object. If you're not physically there, then the officer can look for evidence to put you away. Let's dive into the Payton doctrine. The Payton doctrine is an exception to a warrant requirement where an officer can go inside your home without a warrant from a judge, okay? Let's go through that right now. So the Payton doctrine was decided by a case called Payton v. New York, where the officer would need two things in order to lawfully, not unlawfully, but lawfully go into your home without a warrant from a judge. So the first thing, the officer needs to have an arrest warrant from a judge, okay? Basically, the officer can arrest you lawfully. The officer can't enter your home, because there's a big difference between an arrest warrant and a search warrant to go inside your home, okay? Step two is that an officer needs to have probable cause, specific articulable facts, that you, the defendant, the arrestee, are within your home, okay? So if you're hiding at your friend's house, that's a third party where your friend didn't commit a crime, you did. So if the officer wants to go inside your friend's house and look for you, if you're there, he'll need a search warrant from a judge, because again, you committed the crime, not your buddy, okay? The plain view doctrine, that is an exception to the warrant requirement, which means that an officer can go inside of your home without a warrant, as long as the plain view doctrine is satisfied, okay? So what is the plain view doctrine? The plain view doctrine is when an officer sees incriminating evidence from a public space, okay? So let me give you an example. Let's say that the officer is walking back and forth in a public street, okay? He's in a public space, therefore he's in a lawful domain, right? You take your private property, let's say your driveway, that would be an unlawful domain because that is a private area that's close to your home, okay? So he's on a public street. He looks to his left. He sees that your window is open, and he sees a marijuana bong. That can be evidence enough for him to go inside of your home, get the evidence, and arrest you. Because again, assuming you live in a state where marijuana is illegal, that is the incriminating evidence right away because he can plainly see it from a public space. Therefore, that is enough for the plaintiff doctor to be satisfied. If you have committed the crime, listen very carefully. I'm going to walk through what an officer can do in regards to arresting you with felony charges and misdemeanors. So in order for an officer to arrest you if you committed a felony is when the officer has probable cause that you have committed the crime. As we know, probable cause means that the officer has specific articulable facts that will give him or her a reasonable inference you committed a crime. Okay, let's say there's video footage of you shooting up a bank that you wanted to rob, okay, and you did it. The officer can use that to get probable cause to arrest your butt, okay? If it's a misdemeanor, let's say you stole candy from the store. If an officer witnesses it, he can arrest you right away. If the officer did not witness it, then the officer will need more evidence to get that probable cause standard we're looking for. Okay, so if an officer gets more evidence, let's say he witnesses, let's say footage from the store, to see you steal that candy bar from, let's say, the gas station, that will be enough to arrest you right away. Let me explain to you how an officer can go through your trash and find incriminating evidence within your trash and use it against you in the court of law and basically put you in jail. Okay, let's go through that real quick. So this all started in a case called Greenwood, where a defendant, and this can apply for me, you, and Greenwood himself, okay? He basically got his trash and put it in the dumpster. He got his trash, like, it'll say you own a house. We'll say that, okay? You own a house, you put your trash by the end of the driveway. He basically relinquished his reasonable expectation of privacy within the trash. So whatever is in the trash is technically not his anymore, right? Because he relinquished it. He gave it away to the trash guy, okay? And the officers went into the trash and found evidence within and used it against him, okay? So if he used that trash and it was, let's say, on his driveway or in his garage, the officers couldn't look in there and take it because that's near his home. It's still his at that point. But once he puts it by the public road, it's no longer his. Search instant to a lawful arrest. Okay, I wanted to explain to you what an officer can and cannot do to you lawfully when you get arrested. So let's say you're driving and you get pulled over and the officer arrests you. Okay, the officer has probable cause, has a standard of the law to arrest you, and you're in handcuffs like the guy above, as you can see. The officer can pat you down, number one. Number two, the officer can search your pockets. If you're wearing a backpack, let's say, the officer can search the contents in your backpack because it's on your person, okay? Number three, if your phone's in your pocket and the officer brings your phone, the officer cannot use the phone and put it to your face or your fingerprint and unlock it in order to look for evidence in your phone to find more evidence to put you away. Because in a case called Riley v. California, the court found that you have a reasonable expectation of privacy in your phone, and therefore the officer would need a warrant in order to search your phone. Okay? Lastly, if they see the wingspan of my hand, the officer can look in this side of the car, the passenger compartment, and see if there's evidence in there. Number one, you committed a crime. Number two, the officers have an arrest warrant and they're looking for you. And number three, the officers have a reasonable belief that you are within your friend's home and you're hiding there in order to avoid law enforcement to arrest you. In a case called Steagall's, the court held that the officers cannot go within the third person's home because that third person didn't commit the crime, you did. Therefore, if you're hiding at your friend's house when you commit the crime in order to avoid law enforcement, they will need a search warrant from a judge in order to get into your friend's home in order to arrest you and even find evidence in your friend's home to arrest them as well, okay? Additionally, if they find evidence in your friend's home and they go in anyway, as you can see the picture above, without a warrant from a judge to get inside the home, whatever evidence they may find within your friend's home will be excluded and your friend will be acquitted. If no search warrant, you can be the girl above and say, screw you cops, you can't get in. Anonymous tips. I'm going to tell you exactly how anonymous tipster, basically a snitch like the guy above, can give an officer certain information about your criminal activity, and the officer can use the information in order to pull you over and even have probable cause to see what the heck's going on and possibly put you away for that activity. In a Supreme Court case called Alabama v. White, the court held that the informant, basically the snitch, the anonymous tip, needs to give the officers future events about what you're doing. Okay, example, what time you usually sell drugs. Okay, where you sell drugs, pictures, text messages, videos. Okay, that could be evidence given to the police in order to bust that person. Okay, or even you can work with the cops, the anonymous tipster, and say, meet me at this time and place. And the officers can bust whoever you want to snitch on at that point in time. That could be enough to put that person away. When I say this is not legal advice. This is just tips from a friend. Is that if you get pulled over, do the following. Is that always keep in mind everything that I've been saying in all these videos, because technically speaking, this is the law. This is what the cops can and cannot do you lawfully. However, let's just be realistic. There are a lot of cops who are just fucking dicks, okay? And there are some cops who are very nice and reasonable. Nevertheless, though, if you come across that one asshole cop who has a gun pointed at you, or even a pepper spray pointed at you, follow directions and sue his ass later. Don't challenge the cops, because not only would I look bad in front of a judge and a jury, it will also look bad in your suit if you try to sue the cop later on. Lastly, if you come across that nice cop who is reasonable, voice your rights in a nice way, be professional, and make sure you don't consent to a search if it's not lawful. Another fun fact about getting pulled over that may piss you off is the following. Listen carefully. If you get pulled over to the side of the road, an officer needs reasonable suspicion in order to pull you over, right? Terry v. Ohio explains this very carefully. However, this is the part that's going to make you mad. In a Supreme Court case called Hine v. North Carolina, the Supreme Court held that as long as the officer makes a reasonable mistake in thinking that, oh, okay, I think he's committing a crime and he pulls you over, but it was mistaken, that will still be lawful. And think about it. If you have marijuana in your car, or maybe your eyes are red because you just got done drinking or smoking, you're fucked off a mistake. I'm going to explain to you how an officer can stop and frisk you like our guy in this picture, and how an officer can look in your passenger compartment for evidence if this happens to you. So as you can see, the officer not only stopped this guy, but he's frisking his outer body, right? To search for evidence, to search for a weapon, because he believes that he is armed and dangerous. In the case called Terry v. Ohio, the Supreme Court held that as long as the officer has reasonable suspicion, a specific articulable fact that the defendant is committing a crime, the officer can stop the person. If the officer has a reasonable belief that the defendant is armed and dangerous, that is when the officer can lawfully frisk the person's outer body to search for a weapon. And in another Supreme Court case called Michigan v. Long, the Supreme Court held that as long as the officer has a reasonable belief that the driver and the passengers are armed and dangerous, he can search the passenger compartment to see if there are weapons in the passenger compartment. He can't search the whole car, but the passenger compartment will be lawful. If you ever go on a road trip, be very, very cautious, because there are certain roadblocks that some states have where officers can lawfully stop you without reasonable suspicion. And the first reason why this is lawful is because an officer must have a specific and articulable reason to stop your car or every other car behind you or all the cars behind you. And the second reason is that the officer can lawfully do this if there's a particular issue involving not just you as a person, but just involving your car and its mobility. Example, drunk driving. In a case called Michigan Department of State Police v. Sitz, the Supreme Court held that it was lawful for the police to check the sobriety of every single passenger of every single car because of the gravity of drunk driving. And lastly, think about it. If you're in a state where marijuana is legal, like Nevada or California, and you drive through a state where it's illegal, if one of those roadblocks occur, you're fucked. Hi everybody, I'm going to teach you how to invoke your right to remain silent upon being arrested, like our guy above, and placed into custody. And you're placed into custody when a reasonable and prudent person will not feel free to leave. And also when you're at a police station or in the back of a patrol car, or even at home in handcuffs when the officers say that, hey, you're under arrest. So as you can see above, in a case called Michigan v. Mosley, the Supreme Court held that there are 3 factors that an officer must follow when you invoke your right to remain silent. And when you do invoke this right, be very specific about saying, hey, officer, I am invoking a right to remain silent. The first factor is that the officers must cease questioning right away, and they cannot question you again for several hours. The second factor, the officers must give you a fresh set of Miranda rights. So they must tell you your Miranda rights again before they can question you a second time. And lastly, the officers must ask you about a different crime that was different than the first one. Let me briefly explain to you what custody really is, because as you know, once you're in custody, that's when the officer has to give you Miranda warnings, and that's when you can invoke your rights, and that's when your statements will not be used against you because you invoked your right. So as you can see above, in a case called House v. Fields, the Supreme Court held there's a two-pronged test and understanding when a suspect is in custody. The first prong to this test is the freedom of movement test, which means that a reasonable person under your circumstance will not feel free to leave. Okay? If you're in handcuffs, obviously you can't just feel free to leave and go home. The second prong to this test is the environment being inherently coercive, like Miranda v. Arizona, where you're in a police station or the back of a patrol car, for example. So that is what custody is. And once you're in custody, you get your Miranda warnings, you can invoke your rights, and your confessions will not be used against you in court of law. In McCarty, the Supreme Court held that the officers under McCarty give you Miranda warnings because your stop will be brief when you pull over the side of the road. Therefore, your confessions will be used against you. Let's walk through actual and apparent third-party consent, which is an exception to how an officer can come inside your home without a warrant from the judge. In the case behind me in Illinois v. Rodriguez, as you can see up here, the Supreme Court of the United States held that actual authority is when the person truly lives there, when the person truly has authority in the home, the person's paying rent or the person's name's on the lease. And the Supreme Court held that apparent third-party consent is when the officers had the reasonable belief that the person truly had common authority in the castle, although the person truly did not have authority in the castle. Okay, in this case, in Illinois v. Rodriguez, the person had keys to the place, to the home of the defendant. That's why the officer had a reasonable belief that the person truly lived there, and that's why the consent was valid for the officer to go inside the home and search wherever in the home that he wanted to. Let's go through another search warrant exception. I'm going to teach you how an officer can still search your home without a warrant from a judge if the officer is in hot pursuit. As you can see above, the suspect is fleeing from the officer. He committed a crime, he's going to go to jail, etc. If he runs away, makes it to his home, and the officers have probable cause, he's within the home, they can go inside his home without a warrant from a judge and arrest him. In the Supreme Court case called Warrant v. Hayden, as you can see above in this background picture, the court held that due to the suspect fleeing from a robbery scene and being a threat to society, because obviously if you rob a store, you're clearly a threat to society, you just committed a serious felony, the officers went inside of his home, found him upstairs sleeping, and lawfully arrested him. The court found that this was lawful because, again, they were in hot pursuit for someone who committed a serious crime. And the scope is that once they're in your home, they're going to look for spots where a human being will be in, nowhere else. I'm going to teach you what a detention is. Technically, this is when an officer can or cannot lawfully seize you. As you can see in the background picture here, the officer stopped the car, right? That is when you're technically under detention and a seizure has occurred, and that's when Fourth Amendment activity begins. So in a Supreme Court case called United States v. Mendenhall, that is when the Supreme Court had a two-pronged test in determining when someone is under detention or not. Okay? It's very simple. The two-pronged test is 1, the reasonable and prudent person under your circumstances would not feel free to leave. The second aspect of this test is that the officer used either physical force or a show of authority. When an officer puts on his lights, the reasonable prudent person will not feel free to leave. And that is a show of authority when the officer uses his lights to pull you over. Third-party consent. Third-party consent is an exception to the warrant requirements under the Fourth Amendment. So let's walk through that process very briefly. So let's say you have a roommate in your home. Let's say it's your wife, your mom, or your buddy who you live with. That person has equal authority under the home because they're paying rent. They have their name on the lease. The deed, that will count as common authority under the castle. And if an officer comes to your home, and let's say that's the officer, and that man is your roommate, and your roommate allows the officer to come in your home, the only way for you to prevent the officer from coming inside your home to search the home for evidence is if you're physically present and you object. You have to physically be there. You have to stand there and literally tell the officer you cannot come in. There is something called actual and apparent third-party consent, which I'll go through in part 2 of this video. Hi everyone, I am going to talk about what not to do once you're in custody. Okay, I'm going to teach you what happens when you do not invoke any rights at all. If you just simply do nothing. after an officer gives you Miranda warnings. Supreme Court case called Barracus v. Tompkins, the Supreme Court held that when the suspect committed the crime, got arrested, he was placed in custody, and the officers gave him the Miranda warnings, he did nothing. He didn't say anything. He didn't invoke his rights. He just didn't do anything. He just sat there. The Supreme Court held that once the defendant does that, he neither invokes his right nor waives his right. Therefore, the officer can continue to talk to that defendant, can talk to that person. So if you're ever in custody, invoke your right to an attorney. That's the best thing to do, honestly, because you'll have counsel. You'll have a lawyer to help you out. If not, the police can still question you and F with you. I'm going to explain to you how an officer can search your car without probable cause or a warrant from the magistrate. As you can see above, in a Supreme Court case called Sneckcliffe v. Bustamante, the Supreme Court held that the defendant gave the officer voluntary and knowing consent to the officer, and that is the reason why the officer was lawfully able to check the contents of the car, although the officer didn't have a warrant from a judge or probable cause to believe there's evidence in the contents of the vehicle. And in this case, the defendant didn't even know that he could tell the officer no. But the Supreme Court still said that because you gave voluntary consent to the officer to search your car, that's still lawful because you gave him voluntary consent. Therefore, the main thing to take away from this case, and what I'm trying to tell you, is that giving consent to an officer is an exception to the warrant requirement and the exception to an officer having probable cause to search your car. So if an officer asks to search your car, say no. If you're ever arrested, placed into custody, and the officers interrogate you about the crime, you invoke your right to an attorney. And once that happens, the officers must cease questioning completely. However, I'm going to go through the exceptions to that rule, which you need to be very well aware of. In a Supreme Court case called Maryland v. Schatzer, the Supreme Court held that when a detainee invokes his right to an attorney, the officers must cease questioning completely. And they must cease questioning completely as long as he or she is in custody. Plus, 14 more days after he or she is released back into society. So basically, the person makes bail, let's say, the officers must wait 14 more days after that moment to come back to you and question you about that crime. And again, if that happens, invoke your right to the Fifth Amendment. Have the right to remain silent and say, hey, officer, I invoked the Fifth. I want to wait till I talk to my attorney. I'm going to explain to you why an officer needs a search warrant from a judge in order to search someone's phone who gets arrested. As you can see behind me, in a Supreme Court case called Wiley v. California, the Supreme Court held that the detainee was lawfully arrested. And upon being lawfully arrested, the officer can search the person's body and wingspan. That was lawful. However, the issue in this case was that the officer can only check the physical attributes of the person's cell phone. The officer cannot search the contents of the person's cell phone. Example, the officer can't grab your phone and put the phone like this, or grab your thumbprint and put it like that in order to unlock the detainee's cell phone, because we have a high reasonable expectation of privacy in our cell phones. Therefore, an officer needs a search warrant from a judge in order to look at the contents of one's phone for evidence. Therefore, an officer can look at the shape of the phone and say, okay, it's like rectangle, squarish, but they can't look inside the phone. I'm going to walk through how the officer can search a defendant's home upon being arrested in the home. In the Supreme Court case called Bui, the police officers lawfully arrested the defendant within his home. A second officer searched the defendant's basement and found incriminating evidence within the basement. So as you can see on the board, we have SILA, which means search into a lawful arrest, which means that once the defendant is arrested within his home, the officers can search the defendant's wingspan and the defendant's person. Further, the officers can have a precautionary search, which means that the officers can search an adjoining room without reasonable suspicion or probable cause. However, as you can see on the board, an officer can search the entire home for a protective sweep if the officers have reasonable suspicion or probable cause that the defendant has accomplices in the home that can launch an attack on the officers. And this kind of search must happen contemporaneous to the arrest, no later, or it'll be unlawful. I am going to explain why it is lawful for an officer to ask a detainee for his or her ID. And I'm going to explain why it is lawful for an officer to say, hey, get out of the car. Per Terry v. Ohio, the Supreme Court held that an officer needs reasonable suspicion that the detainee has committed a crime in order to lawfully stop that person. Therefore, Once an officer has reasonable suspicion, let's say this guy has lawfully stopped this man because he passed the stop sign. That's an example of a lawful stop, right? Because he committed a traffic violation. This officer can ask him for ID. And if he does not give the officer ID based on that lawful stop, this man could get arrested for not complying. Lastly, upon the lawful Terry stop, the officer can ask the detainee to get out of the car. That's perfectly lawful. Without a lawful Terry stop, it'll be unlawful. Let's walk through exactly what a valid warrant is. There are 3 requirements needed in order for a warrant to be actually valid. Number 1, we need a neutral and detached judge, which means that a judge is not biased towards the police and not biased towards the detainee, towards the defendant who may or may not have committed a crime. Number 2, the officer needs to write an affidavit by oath or affirmation telling the judge, hey judge, this is the complete truth. This is what I believe in regards to my probable cause to why I think the defendant committed the crime. And this is why I need a valid warrant from you. And lastly, the warrant must particularly describe in specificity where they're searching, who they're arresting, etc. It needs to be very precise, very particular. And there you have it. With those 3 things, you have a valid warrant. If not, no warrant is valid. I'm going to explain how a driver's statements can be used against him or her if he or she confesses anything to the officers upon getting pulled over. In a Supreme Court case called McCarty, the defendant was pulled over. The police officer asked the defendant whether or not he was drunk. The defendant admitted. The defendant stated he used drugs and he was recently drinking to the officer. As you can see on the board, the Supreme Court held that police officers are not required to give Miranda warnings during traffic stops because traffic stops are brief. Therefore, all statements that a driver says to the officer will be admissible. Therefore, our guy, McCarty, was fucked. Therefore, beyond the basic question of why am I detained, the defendant should have shut the fuck up because anything he says during a traffic stop will be used against him. Let's go through what happens when an officer forgets or purposely forgets to give the detainee his or her Miranda rights. In a Supreme Court case called Payton, if the police officers purposely forget to give the defendant his or her Miranda rights, then the evidence will be completely excluded. However, the Supreme Court held that if the police officers did not purposely forget to give the defendant his or her Miranda warnings, then only physical evidence will be permissible. His or her statements will be excluded. So in Payton's case, the officers forgot to give him his Miranda warnings, and the defendant voluntarily stated the location of a deadly weapon. The court held that the deadly weapon will be admitted to evidence. However, his statements will not be admitted to evidence. Therefore, our guy should have shut his mouth and he shouldn't have said shit until he talked to his lawyer. Let's briefly go over what knock and announce means when it comes down to the officers having a valid search warrant to search your home. Upon having a valid search warrant to search your home, the officers must knock and announce that they're there and wait a reasonable amount of time for you to come to the door and open it before they blast your door open like this guy's about to do. However, there is an exception to this rule. As you can see over here, United States v. Banks, the Supreme Court of the United States held that as long as the officers have the reasonable belief that the people within the home are destroying evidence, they can prevent themselves from knocking and announcing in the home, and they can bust their way in and come into your home. Lastly, the Supreme Court held in the case called Richards v. Wisconsin that if the officers have the reasonable belief that someone is in danger, that there's imminent danger to not only the officers themselves, but to another person in the home, they can go without knocking and announcing. Drug-sniffing dogs used by police officers. Let's go through exactly what is lawful and unlawful about this activity when you get pulled over, like our guy above here. So usually there are 2 cops in one patrol car and dogs in the back seat. Okay, one cop gives you the ticket, and the other cop has the dog from the back of the patrol car going around your car like our guy above. This is lawful as long as it does not prolong the stop. Okay, so if the drug-sniffing dog prolongs the stop, then it reasonably should have lasted, then the evidence that they find within your car will be excluded. However, if it's within the reasonable amount of time that it takes to give you a ticket, then whatever evidence they may find in the car will be included. and you can be prosecuted. And lastly, the Fourth Amendment does not protect against you having illegal drugs in your car. Therefore, you do not have a reasonable expectation of privacy when a drug-sniffing dog searches your car and indicates that there are drugs within. If you are ever in custody by the police, listen to the following. I'm going to explain to you what they can and cannot do to you lawfully when it comes down to using your statements against you. So when you finally get handcuffed by the cops and they want to put you in the back of a patrol car, or you're at the police station and they want to talk to you about certain things, this is what's required. Listen very carefully. Police must give you Miranda warnings. The Miranda warnings are as follows. You have the right to remain silent. Anything you say will be used against you in court of law. You have the right to the presence of attorney. And if you can't afford attorney, one will be given to you, if you so desire. Before I continue, I want to preface by saying that I wouldn't say shit until I talk to my lawyer. Think about it. It is the whole government versus you. If you say incriminating statements against yourself and the officers happen to forget about giving you Miranda warnings, it will be inadmissible in the court of law because Miranda is required. Therefore, to wrap it all up, if you are in custody and they give you Miranda warnings, specifically say that you want to talk to your lawyer first. Hi everyone, I'm going to teach you how to invoke your right to the presence of an attorney, and I'm going to tell you what the cops can and cannot do to you once you invoke this right upon getting arrested and getting into custody, as you can see above from our guy. So in a case called Edwards v. Arizona, the defendant told the officer that, officer, I want to talk to my attorney first before I talk to you. I'm invoking my right to an attorney. He specifically told the officer what his right is, and that's what you should do as well if you're ever in custody. If it's vague, it won't work. Your right will not be invoked then. The Supreme Court held in this case that once a suspect invokes that right to an attorney, the officers must cease questioning completely. They cannot come back and talk to you at all. They can only do that when you initiate the conversation again to the officers about the crime, or if you have a presence of attorney at that interrogation.